How do you advise families who aren't sure if the veteran had pending claims at the time of death?
Well, the first thing I would suggest to folks is to contact the local Veterans Regional Office and speak with the folks there. If you want to be absolutely sure, then you can file a request for substitution, and the VA will tell you whether there were any claims that were actually pending. But it's easier usually just to ask.
Is there any difference in how accrued benefits are treated at the regional office versus at the board?
Only in the sense that all cases reviewed at the board are being looked at by a more sophisticated group of decision makers.
A more legally, case law, etc. oriented one?
Yes. I mean, one of the things that I've found over the years, in fact, I once had a decision review officer just come right out and say to me, well, I can't do that at my level, but if you take it to the board, they'll probably grant it.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA. If you're a veteran struggling with the VA's disability system, or just want to make sure you're getting the benefits you've earned, you're in the right place. Don't forget to hit subscribe so you never miss an update that could change your life. I'm Alexandra Jackson, here with renowned veterans disability attorney Francis Jackson of Jackson MacNichol. Jack has dedicated his career to helping veterans like you win the benefits you deserve, recovering millions of dollars for thousands of heroes. This podcast isn't just for veterans navigating the system. It's for their families, their friends, and anyone else who wants to stand shoulder to shoulder with those who served. So stick around, because we're here to make sure you get the support you need. And today's show is about accrued benefits.
That's an interesting topic.
Yeah, let's start at the top. What exactly are accrued benefits in the VA system?
Accrued benefits in the VA system mean benefits that a veteran was entitled to before his or her death, but which have not yet been paid.
And how does that differ from dependency and indemnity compensation or survivor's pension?
Those are very different. Both dependency and indemnity compensation and survivor's benefits are based on the entitlement of the survivor and go on for that person's lifetime, or in the case of survivor benefits, as long as they're financially eligible.
Who is eligible to receive accrued benefits after a veteran passes?
Generally speaking, accrued benefits are limited to spouse, children under 18, children who became permanently disabled before the age of 18, children who are between 18 and 22 and in college, or parents who were dependent upon the veteran for their financial support during the veteran's lifetime. The other piece, if you will, is that anyone who paid toward the expenses of the veteran's last illness, or funeral or burial or transportation to the funeral home and so on, or those kinds of expenses, is eligible for accrued benefits to the extent that they can show they made those payments that I've just enumerated.
So they wouldn't get the whole amount. They'd be limited to whatever they actually paid.
Yeah, there's a bad case, what I think is a bad case, from the Federal Circuit holding that. I am hopeful that that's a decision that will ultimately be reversed. But right now, the case law is that those who are entitled to accrued benefits based upon payment toward cost of last illness, funeral, burial, transportation, etc., only get reimbursed for those amounts.
Is there a time limit or deadline for applying for accrued benefits?
There is. You must apply within 1 year of the veteran's death.
And do accrued benefits apply only if the veteran had a pending claim at the time of death?
Yes, there has to be a pending claim or a claim that's been granted, but the actual benefits had not yet been paid.
What happens if the veteran had filed a claim, never had a decision on it before, and that was pending at time of death?
Then the accrued benefits claimant can substitute for the veteran, and pursue the claim to completion.
So, can a surviving spouse or other eligible person continue a claim in progress, or does the VA
Yes.
require a new application?
No, as long as the person properly files for substitution, they can pursue the claim in progress.
So they have to file something, but it's not 21-526EZ or 0995.
That's right. They have to file, I forget the form number, but there's a form specifically for substitution that they have to file, and they have to file one of the forms for accrued benefits. There are a couple of different forms that you can use, but they have to file at least one of the accrued benefit forms.
How do children or dependent parents qualify for accrued benefits if there's no surviving spouse?
The way the statute is created, the VA can pay benefits to people in an order of preference. First preference is their surviving spouse. Second, it's children who became permanently disabled under the age of 18, or children who are currently in further education and between the ages of 18 and 22. All of those categories kind of come together and come in behind spouse. So if there's no spouse, it's that group. And then if there's no one in that group, then parents who can show that they were financially dependent on the veteran during his life can apply for the accrued benefits.
How far back can accrued benefits be paid out?
As far back as the claim goes, I mean, as you know, sometimes there are claims that are just kind of stuck in the system that VA has never processed, and they can go back literally decades. But more typically, it will be a claim that the veteran has been actively pursuing, and it just hasn't been resolved favorably during his or her lifetime.
How do attorneys approach cases where VA denied the claim before the veteran died, but an appeal was still possible?
Well, the way that works, VA calculates the 365-day, 1-year appeal period up to the date of the veteran's death. And let's just say that, to use easy numbers, the veteran was denied, there was a decision denying the benefits, and the veteran died 200 days later. What the VA would say is that if a person substitutes, they have the balance of that 365 days to file the necessary notice of appeal, called a notice of disagreement, and proceed the appeal.
So it'd be awkward if they died on day 364.
Very awkward.
Okay. Are there common mistakes survivors make when applying for accrued benefits that can cause denial?
Oh, there are lots of mistakes that people make. It's like all the mistakes that veterans make themselves when they apply that lead to denials. But the place that there's a lot of confusion and difficulty is a lot of folks don't realize that they have to file both a request for substitution and one of the various accrued benefits forms within 365 days of the veteran's death. And unfortunately, if you miss that deadline, then it's over. There's no reopening that.
And that's in contrast to DIC and survivor's pension.
Right, because those can be filed at any point in time.
And can new evidence be introduced after the veteran has passed, or is the decision based solely on what was already in the file?
It all depends. That's a good legal answer, right? If a person files for substitution and is substituted on the claim, they can offer new evidence. If they just file for accrued benefits without substituting, they can pursue the claim, but they can't offer new evidence. So it's always important to file for substitution.
Okay. Are there specific types of evidence that carry more weight in accrued benefits claims?
I don't think there's really any difference there from any other claims. I mean, the claims, whether you're talking accrued benefits or any other kind, are typically denied by the VA for one of two reasons. Primarily, claims are denied because the VA is not satisfied with the medical evidence linking the current medical condition or the medical condition that the veteran had before his death or her death with what happened in the service. So usually the type of evidence needed is an expert medical opinion explaining how what happened in the service led to the current condition. Secondarily, and much less common, there's some issue about factually what happened in the service to make it a basis for the current condition. And, that can be all over the lot. You can't really characterize that because there's so many variables.
How do you advise families who aren't sure if the veteran had pending claims at the time of death?
Well, the first thing I would suggest to folks is to contact the local Veterans Regional Office and speak with the folks there. If you want to be absolutely sure, then you can file a request for substitution, and the VA will tell you whether there were any claims that were actually pending. But it's easier usually just to ask them.
Is there any difference in how accrued benefits are treated at the regional office versus at the board?
Only in the sense that all cases reviewed at the board are being looked at by a more sophisticated group of decision makers.
A more legally, case law, et cetera, oriented one?
Yes. I mean, one of the things that I've found over the years, in fact, I once had a decision review officer just come right out and say to me, well, I can't do that at my level, but if you take it to the board, they'll probably grant it. And it's because of the way the system works. At the regional office level, you've really got to fit all the square pegs in the square holes and the round pegs in the round holes and check all the boxes. Whereas at the board, they're a little more sophisticated about how things go together, and you won't run into typically quite the same level of, well, this doesn't fit perfectly with the M21. You get a little more common sense, if you will, a little more leeway. I don't know how best to describe it, but there are cases that you clearly can get a better result at the board than you did at the regional office.
And by the M21, you're referring to the VA manual M21-1, right?
I think we're at M21-5 now, but yeah, it's
call it the M21-1.
It's
so
true.
Forgive me.
It's true. No, it gets called that. Yeah, that's simply the VA's internal manual for processing claims. It's huge. It has, I don't know how many subsections and sections and subsections. It just goes on forever, it seems like. But yes, at the regional office, if you can't show that you are entitled to win based on the M21, you're probably not going to win. At the board, it's a more sophisticated analysis.
What should a surviving spouse or child do first if they think they may be eligible for accrued benefits?
The first thing I would suggest they do is contact the regional office. Talk to I forget what they call it, the public information team, I think it is. Talk to those folks and just say, gee, my husband, father, whatever, just died, trying to understand what's going on with this case. Can you tell me where things stand? Are there any appeals pending? Are there decisions that haven't been appealed? And kind of get the lay of the land. If you are not satisfied with that result, as I mentioned earlier, you can always file the request to substitute, and the VA will be forced to look at anything that's currently pending and open and consider whether you are an appropriate substitute.
And finally, what message would you give to veterans about planning ahead so their families don't miss out on accrued benefits?
Well, I mean, there are really only two things. One is
file your claim.
File your claim.
Because they can't start a new claim for service connection without you.
Exactly.
A claim for increase, a claim for service connection. It's got to come from you, the veteran.
That's right. So file your claim and pursue it and hopefully resolve it in your lifetime. But the second thing I would say is, if you have claims pending, talk with your spouse, children, whoever, about what those claims are and about whether you want them to pursue those claims if you die before they're resolved. I mean, be clear about that. There are, as you know from doing so much estate planning, there are all kinds of things you can say to or leave word about to your survivors as to what you want done. And one of the things you can say is, if my claims with the VA aren't finished, I really want you to pursue them and file a motion to substitute.
Yeah. Well, thank you all for joining us this week for our discussion of accrued benefits. Don't forget to like and subscribe, and we will hopefully see you next time.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.